Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. All right, now without any further ado, I would like to introduce our moderator and leader for this presentation, Gideon Kracov, who's one of our panelists here with ADR Services, Inc., and brings over 30 years of experience resolving complex environmental disputes to the table. I will let Gideon take over introductions of all of the panelists and for himself. So Gideon, thank you for putting together this program, and take it away.
Do we have the slides up there, Katie? Am I looking for those?
Yes, sir. I will pull our slides up and I can introduce your speakers this afternoon.
Right. Let's go to the first slide there, just so folks can see our topic here. Can we go to our first slide just for a second? There it is.
Yes, sir.
That's us today, everybody. So I want to thank the folks. I think we had 200 attendees signed up today, so that is just terrific to have all of you participating. And we'll go to the next slide so I can introduce our terrific panel. I'm going to mix up the order a little bit. We have Alison Torbitt here today. Alison's a partner and co-lead of the environmental and sustainability practice at Nixon Peabody in San Francisco. She focuses on compliance and transactional due diligence, all aspects of environmental law, including the latest developments on emerging contaminants like per and polyfluoroalkyl substances, PFAS, as well as difficult subjects like vapor intrusion. Alison has a science background as an aquatic ecotoxicologist and a heavy background in working to clean up contaminated sites. She's really at the top of the field, the top band in this area, and this was really her panel concept today. Thank you, Alison. Next, we'll talk about Jon-Erik Magnus. He's a shareholder at Rogers Joseph O'Donnell in San Francisco, where he represents Fortune 500 companies, all the way to small family businesses in all aspects of environmental and regulatory matters through California and Washington as well. Prior to becoming attorney, and pretty relevant to our panel, Jon-Erik spent 10 years in the insurance industry handling environmental and toxic tort claims. He's very familiar with the environmental insurance coverage issues that arise in the topics we're talking about today. It's a key aspect of his work. He also has a wonderful, dry sense of humor that I hope we're going to get to hear a little bit about today. Kit Cole is a good friend and an owner of Kit Cole Consulting in Los Angeles. She's a nationally recognized expert in working with stakeholders and community groups in high emotion controversies and crises, especially in communities heavily impacted by industry and environmental risk. She has more than 30 years experience working for Fortune 200 companies like Southern California Edison. Have you heard about them in the news lately? Or Waste Management, as well as in the public sector, with a focus on developing third-party coalitions and engaging with communities around these projects. She also chairs the LA chapter of the International Institute for Association for Public Participation. And my name is Gideon Kracov. I'm a full-time mediator at ADR Services based in LA, where I work on real estate, civil, and environmental matters. Lawyers hire me to help resolve their disputes, to reduce reactivity between the sides that occurs in lawsuits and conflicts, to help the parties focus on their common interests instead of only their litigation positions. And for identification purposes only, I'm the former governor's appointee to both the California Air Resources Board and the South Coast Air Quality Management District. I also teach land use law as a member of the faculty at Loyola Law School. Let's go to the next slide, please. All right, folks, so Earth Day, the 55th Earth Day was earlier this week. It marks the birth of the modern environmental movement in 1970. By the end of that year, Earth Day led to the creation of the United States Environmental Protection Agency, and then shortly afterward, to passage of other first-of-their-kind environmental laws, including the National Environmental Policy Act, the Clean Air Act, and the Clean Water Act. For each generation, each new year, Earth Day asks us to confront new challenges. Now, we certainly have uncertainty and disruption now at the federal level on environmental and climate policy making. Certainly in the aftermath of the Southern California wildfires, we have challenges, don't we? Confronting climate change, rebuilding. In our state, we need to build abundantly for a green, decarbonized economy to achieve the sustainable, equitable future we all imagine. Our housing demands require an estimated 120,000 new units each year. An enormous quantity of public infrastructure is needed to meet our state's goals. And we have the World Cup and the Olympics coming to Southern California soon. This is the second Earth Day webinar we have done at ADR Services since I joined our terrific panel as a mediator. Last year's was about the role mediation and facilitated dispute resolution can play in helping to build an abundant California, settling acrimonious permitting and land use disputes, including settlement strategies and negotiation tips for California Environmental Quality Act cases. This second webinar today continues on that theme. Yes, there is global and policy uncertainty in Washington, D.C., but what can we do at the local level to revitalize our communities? What can we do to take contaminated, underused land and property in our communities and put it back to productive use? To think global on Earth Day, but act local. What better way is there to celebrate Earth Day? And I want to thank you, panelist Ali Torbitt, for this idea. So today in the next hour, we're going to hear from expert lawyers and consultants on how to facilitate negotiation and settlement of dirty dirt property contamination disputes. Here's our agenda. We're going to present a mixed-use housing hypothetical and discuss best practices for navigating the government oversight process, environmental forensics, and liability protections. And Ali Torbitt's going to lead that segment. Then Kit Cole is going to discuss public participation and how do we communicate environmental risk. And then Jon-Erik is going to present litigation tips, working with insurance, and I may chime in there too on some settlement and negotiation advice. So we have just an hour. We have a lot to cover, probably not a lot of Q&A today, but we will give you contact information for each panelist, and please follow up with us individually afterwards. So that's our agenda. Let's go to the next slide. And we're going to turn it over to Ali with our hypothetical.
Thank you so much, Gideon. Thank you, everyone, for joining us today. I'm very excited to be here to present this hypothetical and to work through it with these wonderful presenters. So thank you and welcome. So the idea on this is, as I said, this is a hypothetical. It's based on an amalgam of multiple cases I worked on that I kind of put together into one. Often it's times an affordable housing developer decides they want to acquire a strip mall. So they go out and they get what's called a Phase 1 environmental site assessment. A Phase 1 environmental site assessment is a very basic tool used by the EPA to what's called all appropriate inquiries. So it's kind of the basis for any due diligence to say, hey, does the site have any environmental conditions, recognized environmental conditions, which is either a pollution's already occurring, there is a likelihood or threat of pollution occurring, or a preponderance of evidence saying that there is a possible pollution in the future. So those are kind of three main signs of what a REC is, recognized environmental condition. So they do a Phase 1. And a Phase 1 is a non-invasive investigation. It involves interviews with the owners and operators. It involves lien searches, looking for environmental land use covenants. You go through the government records and government interviews, see with the local fire department, environmental health divisions to see what's happened on this site. There is a site inspection, which is supposed to be an on-site visual inspection of the property. You look for dying trees, you try to see if there's any sort of open containers of hazardous materials. And there's a declaration by the environmental professional saying that they have done their job and they're a qualified professional and done it correctly. Again, there's no drilling, there's no sampling, but it is a kind of a multi-component project and it's done within 180 days of the transaction closing. Now, there's all different flavors of Phase 1s, and you'll see there's different types of consultants, which is why it's very important to have a good team. What we call a clean Phase 1 is a Phase 1 that shows there's no recognized environmental conditions, there's no concerns. However, I've seen a Phase 1, you go through the pictures and I'm like, these are all Google satellite. They actually used a little dude on Google to walk the streets and determined that that was, clean, they saw nothing. Of course, that is not the same as being there in person and actually walking the actual property. So that would be an example of a clean Phase 1 that probably was not done very well. I saw another one, which you actually could go through, and there was a shed there with a poison symbol on the top, which they some in the historical pictures from the 20s, 30s, that somehow was just never, even discussed or looked into by the consultant. So in this case, there's quite often you'll see a clean phase one that is not actually clean. It's more a symbol of just poor investigation process. So you'll have a developer then that has this phase one. They only read the executive summary. Look, it's clean, looks great. You purchase a strip mall. We're going to build housing out there. They then come in and get the financing parties involved. It's going to be affordable housing. You'll have HUD involved as well. And they look through and they do their own phase one. Depending on sophistication, the financing party, they usually have a better consultant who might come out and actually find something wasn't there before. So in this case, in our hypothetical, they're finding a former dry cleaner. So if it's an old strip mall, there's probably been many tenants over years. There could be a dry cleaner, could be only a 1-year tenant back in the 60s. That 1 year, they could have done a pretty bad job of discharging all their chemicals right into the sewer system. So that happens. The bank or the financing party says, hey, we have this recognized environmental condition. There's a likelihood of contamination. And then they order what's called a phase two. The phase two is a subsurface investigation. They actually will go out and drill some holes. For the dry cleaner, they're worried about TCE and PCE, so looking for soil vapor. There'll be little soil vapor canisters. It could be indoor air in the currently existing strip mall. And they go in to see what's there. In this case, that phase two comes back sky high in TCE and PCE. So now we know we have a developer who had a clean phase one. Now has all of a sudden discovered the fact that, hey, we have a potentially major problem here. And the next step, they start doing investigations to see how major is this problem, and they'll start going off-site. And of course, they want it to be residential, so they have to get to residential standards, even though it's currently commercial standards, and they want to know what's going on around the property. So that is a hypothetical and where we're starting out now.
Great. And now they've hired Alison Torbitt at Nixon Peabody. So where do we go from here? Next slide, please. The maze you've got to navigate, right?
Exactly. So the first maze you get to is who are the players and who's everyone's going to come into there and be your actors in this maze. So you have the developer. You have different risk tolerances and different amounts of how much is this penciling out. Sometimes the project is already going to be very profitable and there's an extra $1 million there for environmental. Sometimes it's a $7 million, $9 million cleanup. There definitely isn't rarely 7 or 9 million just sitting around waiting to help clean up this property. You have, again, the financing parties, which may all of a sudden have been on the hook. They gave you the phase one, they did the phase two, saw the problem, and they might have just disappeared and are all of a sudden gone. So now you have a developer looking for new financing parties. And you, of course, have HUD, the Housing and Urban Development. So with an affordable housing project, HUD is involved. They have their own environmental specialists and their own checklists that have to be all checked off in order to get that HUD funding in the door. You have your government and oversight agencies. So in order to usually pass HUD funding, you rarely can do, it's called like an independent oversight. You have a professional engineer you hire to give you that contamination oversight process. So instead, you're going to an actual agency, which could be the DTSC, Department of Toxic Substances Control. It could be the Water Board, which would be your local regional water quality control board. Or it might be what's called a certified 304 local oversight agency. Alameda County, Santa Clara County are two local ones here. LA Fire Department, down by Gideon. So these local agencies have gone through a process to be an equivalent of the Water Board or DTSC process, but they are different. So the local oversight agencies, each one has their own personalities, you can imagine. Sometimes they do things very conservatively. Sometimes they're a bit more liberal in how they read things and how much they require. Sometimes,
on this topic, you can potentially work with the DTSC. Normally that's for a bit more heavier type of sites that have more extensive contamination. You've got the water boards, each one, there's 9 of them, I think, in California, each with their own character. You've mentioned these local agencies. Do you have a preference? Are there agencies you prefer to work with? Are the relationships important? How do you evaluate this in terms of what agency you go to? And do you have that choice?
You do, and that's an important question they're getting. Is half the people don't ask that question. They just go ahead and register, sign up for the voluntary oversight application, and go through the process. But it's really important to ask that question and what you need. If it's got a water aspect, then maybe the water board's the right place to be. If it's more DTSC has its own very regimented requirements. That while it can be slower, it actually is more predictable in some ways than the water board might be based on which case manager you get. And the LOAs move very quickly. So there's chance the local oversight agency is already side by side with the building department, and they can move things sometimes, 24 hours, which you're never going to get with DTSC. So it depends on where you are in that process, and that question is really important.
Okay.
Each of them will do what's called a pre-application interview process. So you can sit down with them and actually discuss the site before you've even signed up for the application. And you would discuss that phase 2, where you are, the next steps you're doing. And as long as you haven't started remediation or mitigation, you're only in the investigation stage, you can put off that application process until you actually have decided who you want to go with.
Is the best practice to have the lawyer engaged at that point, or is it okay for the consultants to sort of do that interaction? When do the lawyers get involved?
So the earlier the better. So the earlier you get me involved, the earlier I can tell you, hey, this is the agency I think we should go with. You'll usually have a consultant which will have their own opinion. Sometimes it's the same, sometimes it's not. When it's not, it's worth always discussing. Like it's not always a straightforward answer. It should be the best to go with the water board, for example. It's worth that discussion back and forth, and sometimes it changes. You'll also might have a way to get in front of a certain case manager at one of these agencies. So if there's an adjacent site that's already regulated, for example, you have a good chance of getting your site will be assigned to the same case manager because they'll be similar, let's say, vapor intrusion issues. And then you'll want that to make sure that's part of that process.
Got it. Okay. Now, and talk about the public and the other PRPs, as they call them.
Yeah, so next big player is the public. This is everything from your neighbors. So if it is indeed a volatile site, the groundwater, if it's shallow especially, we'll talk about vapor intrusion. It might have offsite neighbors that are also impacted. You'll need access agreements with them. They also are part of the public review process for either the remedial action plan or corrective action plan, depending on what agency you're with. You also have the GeoTracker and EnviroStore, which are public document databases available to anybody. So also that number of public kind of quadruples each part of this. Not to mention also the CEQA and NEPA aspects that also bring the public in, which Kit will help us deal with that part of it. But you can have people who say like they want their heads in the sand, they don't want their property values to go down, they don't want to know about this. They might be against the redevelopment already, and they wanted to keep, that Starbucks next door. And they're now actually pissed off with the development. And now they actually have different motivations in trying to stop this. But the public's definitely there. And then the last step is other potentially responsible parties. These are the prior owners and operators, let's say that dry cleaner. It could be a tenant that's now gone. You start what's called insurance archaeology. You try to figure out who else might be responsible. And for each of these parties, you're trying to place the blame on somebody else. But of course, you need to be careful. You start talking about endangerment. This is an endangerment to the community. That gets the public then really angry, right? Because now they're like, whoa, what do you mean endangerment? Is our human health at risk? And so each of these parties now come into this play as you're trying to navigate this maze.
Got it. And are you bringing the PRPs and the other parties into the maze at this early stage, or are you just trying to keep it simple, Alison?
So it all depends, which is why it's important to have a good attorney behind you to think about this and think about the strategy. So if the PRPs are sophisticated, they've been part of this, especially if you need their money, you might bring them in early. Sometimes that insurance archaeology process takes years, and they're obviously not going to be there for quite a long time. But each of that process could be very long or short, depending on what it is. There might be notification requirements of their past tenants in that lease. So now that you know of a problem, you don't want to run up against those notification requirements or, of course, the statute of limitations.
Right.
So it depends. The classic lawyer answer.
It is a maze. It is a maze, isn't it? And that's why we have panels like this. Let's go to the next slide.
So again, Gideon was just bringing up, it's important to bring the right team together. Each consultant has different specialties. So you want to have the right consultant on hand. There's certain consultants who are just amazing with the public, especially in very complicated situations, taking that complicated process and breaking it down to readily available pieces. There's also, you'll have different types of attorneys, some of which are more litigation focused and actually more adversarial, and other ones that are more cooperative, and I would say, bring a bit more sunshine to the process, kind of like myself. But you have those different perspectives each way. And it depends on what you need for the process and which one's the best one to have. Again, you'll have oversight agencies. So you want to make sure you're the right person available to interact and cooperate with those agencies and make sure all the different parties are on sync. So I always kind of step back and go, what's the end goal? What do you want to do? Usually it is build the project. You want to build that project as quickly and as cheaply as possible. And then you have to think back, like, well, so what does that mean? What do you need to get there? Is it bringing in those responsible parties to help the process and litigation? Is it maybe you haven't finished the purchase agreement yet, or maybe there's another buyer online? You can then set it up differently to go ahead and have different purchase agreement provisions. Maybe there's access to the neighbors, identification you can offer. Environmental insurance is also one there. That's the term future insurance. So there could be like cost cap on the remediation. It could be the future pollution that's part of this. So thinking about all these aspects and putting it together to how to best solve the problems.
Can I ask you a question there quickly? We talked about 15, 20 years ago, or, what they called NFAs, no further action closure on a site. Are those the words we use anymore? What are the goals and what you're looking for in today's parlance?
So in these days, we talk about long-term closure, like LTC. So it used to be no further action. That was like the golden goose. We still get no further action on occasion, especially on UST sites. So underground storage tank, like leaking underground storage tanks, where it's a petroleum-based contamination that you can go and do some excavation and clean that up. On a site like this, the dry cleaner for hypothetical, the NFA is probably never happening, sadly, in today's current climate, but you are getting a long-term closure, which means you actually put a covenant on the site saying, hey, no drinking water, you can't drink the groundwater. And there'll be some sort of vapor intrusion mitigation system in place, of VIMS, and you're making sure that it has proper operations and maintenance in place for it.
All right, so we'll talk more about that in the next slides. Let's go to the next one, please.
So I put this slide in here as we start to talk about these offsite neighbors and are they being impacted by the vapor intrusion that's going on your site you've now just discovered. And it's important here to bring in some good consultants because as you can see kind of here's an underground river. It's actually the blue dots going through this. So the groundwater flow is actually moving as it goes from site to site to site. So it takes a lot of holes in the ground and a lot of access agreements to go out and kind of build together this whole picture. But a good consultant will go through GeoTracker and EnviroStore, find all of the historical investigations that's gone on, piece together a story that's telling you how the groundwater contamination is moving, and thus which properties might be impacted by vapor intrusion.
Is it better to have a site with deep groundwater that's contaminated, or a site with shallower groundwater? Is one more dangerous to the public and the other is easier to clean up? Or what's your sense of the depth of groundwater and how important that is?
So it's definitely important to know. Of course, it depends there on what you're looking for. If the groundwater is polluted by somebody else, then you want it to be deep because it is probably not going to influence your vapor intrusion and your current occupants. However, if you have to clean it up, if you were the party that somehow polluted it, or you're owning the property that the pollution is the origin of that pollution, it's very difficult to clean up deep groundwater. I have a site right now that's got 300 feet down groundwater trying to clean up through bedrock. We're talking about 30 years, 50 years of cleanup, which is very expensive and will probably never actually get to cleanup standards. So it really depends on what you're looking for in your goals.
Yeah, that depth to groundwater is an important question. All right, next slide. All right, the big hot topic.
So building on that depth to groundwater being important, the idea is vapor intrusion, which has the main impact here on whether or not you have the groundwater contamination coming up through the soil and impacting the homes there above. So if there is a basement, which is not very common here on the West Coast, but definitely is the East Coast, the idea is that those soils come through the ground, getting through the foundation of the basement, and are actually impacting the occupants. In a normal house, it's getting through that foundation into the building. So it could be cracks in the foundation. It could be elevators for our strip mall example. Each of those things are going to have more and more problems getting to where you are and whether there is indeed a vapor intrusion at risk. And this is important here because the vapor intrusion standards we work with now were changed in 2019 to be more conservative by the San Francisco Bay Regional Water Quality Control Board. And those are actually now implemented statewide. I'd say informally are implemented statewide. So even in LA, you'll see them apply the San Francisco Bay standards from 2019 to show this very conservative whether or not there is a risk to current occupants.
Can I ask you a couple questions on this?
Of course.
I know we've got about 35 minutes left, but I just can't help myself. What do you advise clients on a soil vapor? Are you able to get through these issues, or does it just take forever with lots of human health risk assessments from OEHA? Or the agencies are not standard? Can you get through this process, and can you get a remedy together? I mean, especially for new builds, it's a little easier for new builds than for retrofits, right?
It's exactly right, Gideon. It's definitely easier for new builds because you can put in a vapor intrusion mitigation system into the process and just build that as part of it. And that vapor intrusion mitigation system can be as easy as a thicker foundation or some sort of kind of laminate coat on top of that foundation, like a retro coat, they call it. So it can be a very easy process. Again, it's having a good consultant there who has professional engineers on staff who are able to help you and are knowledgeable in the systems, and an attorney as well that can work with the regulatory agency to get it approved. But it can happen quickly. It can take years. It can happen very quickly. It depends on how good the team is and whether or not you know what the goal is and you can get yourself to there.
One other question on this. Our site, it's going to be a mixed use project. I guess we're going to have to clean this up to residential vapor intrusion standards. For other sites, can you do commercial or industrial vapor standards, or are the agencies insisting on residential for any kind of use?
You could definitely use commercial or other standards for a commercial site or industrial site. The exception might be like a preschool or a sensitive use like that. Sometimes they'll require residential, even though a preschool is commercial. The other way you can sometimes get around this, if you can install ground floor parking and knock your residential up to second floor and above. You might be able to do commercial on the ground floor for that parking and the residential starting at floor 2. And that gives you that entire, 10 feet of air column to help continue to attenuate those vapor intrusion factors.
Got it. Yeah. Well, it seems like vapor intrusion is coming up in every site, and really important to have a good team of people when you.
Unless, I was going to add for our hypothetical here, if you still have a commercial, that strip mall sitting there, and if it's emptied, it's a great time to get in there and do some indoor air testing. And maybe that current foundation that's already 50 years old is already sufficient enough to stop that vapor intrusion. You can actually make a pretty good case with those investigations saying, hey, this site's not that dirty. Like, even if it's dirty down there, 100 feet down, up here in the air form is already fine. We're going to put in a brown new foundation, a new building. We probably don't need anything here.
Great. Let's go to the next slide.
So this is the importance of that phase 1. As I said, there's the 5 main components that must be complete within 180 days before you purchase. If you have that phase 1 in process, you have these 3 circle defenses, which are the innocent purchaser, the bona fide purchaser, prospective purchaser, contiguous property owner. We're going to have Jon-Erik talk to us about litigation later on. But if you don't have a phase 1 that's valid, first off, there's certain state and federal, maybe federal grants that are available to you, depending on the new administration. But those grants you often don't qualify for without having that phase 1 that was viable and completed. In addition to your defense for those litigations. So it's really important to have it in place. And I bring up here also due care. So that phase 1 also requires you to continue to have due care. So once you discover that problem from say the bank called you and said, hey, we did this phase 2, it's sky high. If you are the developer like, no, I'm not interested anymore. I'm going to go ahead and just let this go or bury that phase 2 and never tell the next bank. That is a violation of your due care requirements. And that comes back to get you because again, you don't qualify for the defenses anymore or those state funding programs.
And then we'll turn it over to Kit in a second here. Do you have to think long and hard about when you talk to the regulators? Are you nervous sometimes you may get an order as opposed to a voluntary agreement? Are you concerned that sometimes, we found some vapor here, now we're opening up a can of worms with the regulator? Any advice on what to tell the regulator and when?
Again, it's important to have a really good team with you so it knows the regulator and knows how they're going to react and can kind of predict for you what's going to happen next. It's always kind of it depends on who you're working with and how well you know them and what's the next response to that. But there's always some variability in that. And certain case managers are very easy to predict and some of them are very difficult. in addition, there's other cases they have. So each of them have other cases they're seeing. We had one here in the Bay Area where Alison, a high school, had an old dry cleaner nearby, and they got evacuated because they had indoor air. They went and tested, and it was sky high, and these high school kids had been in that building.
Mm.
So things like that come up on the news, and all of a sudden everyone else is more nervous about what happens next.
Right. Yeah. Well, that's a good segue to Kit. Let's go to the next slide. We're talking about, communicating environmental risk. There is going to be public participation or P2 requirements for all of these sites. We've identified here, if you've got a water board site, here are some sections from the California Water Code that you can look at that talk about public participation for these kind of sites, both for cleanup and abatement orders, where the agency is telling you what to do, or these voluntary programs where you're sort of in more of a collaborative posture with the agency. If you've got a DTSC site, we've set out there below the very detailed public participation requirements under the Health and Safety Code, which a little bit mirror the federal protections there. And of course, if you're doing CEQA, we're trying to reuse this site. We're going to need land use permits for our new mixed use hypothetical site. There's going to be a CEQA process that also will require public comment, in some cases public hearings for approvals. So you're going to have to deal with the public at these sites. And the question is, how's the best way to do that? And now we're going to turn that over to Kit Cole. Next slide, please.
That's great. And thanks, Alison, for your presentation so far. I've learned a lot, so I appreciate it. Yeah, so public participation can be a little bit of a Pandora's box, right?
Let's go to that next slide, please, if we can.
We want to talk to the community about what we're doing. But often folks are really concerned about once they go out to the community and share with them, they're going to get the community scared, or the community is going to become enraged and then become a barrier for what the developer wants to do. So there's always sort of a Venn diagram here. Alison's talked about the public, about the government agencies. My specialty is the public, and then all of our attorney friends who are on today are in that bottom part of the Venn diagram. So my conversation with you today is about the public and how the public plays into the processes that Alison has been talking about. Can we have the next slide? Great. So we understand that communities often see risk differently than we do, especially all the folks who are on the Zoom today. So communities are very worried and see high risk in something like an oil refinery. They don't see a lot of risk in something like a Diet Coke. And in reality, there is often a lot more health hazard risk if you're drinking 4 or 5 Diet Cokes a day. This is no knock on Coke. By the way, I love Diet Coke. Also love oil refineries. And so as we approach the public, we just want to keep in mind that the public may be seeing our facilities, they may be seeing the actions that we're taking, and they may be making up a reality for themselves or making up a story for themselves about what's happening at the site. So that's why it's so important to talk to people about all that work that Alison and her team are doing on the site, so that folks know the facts about what's happening at the site. And I meet a lot of developers who are like, no, Kit, we're not quite ready to tell folks. And I would just caution everyone, the longer you wait to talk to people in the community about the project, the more the community is going to make up a story or make up its own narrative about what's actually happening there. And that narrative can be harmful to you.
In these kinds of cases, Kit, a lot of this is environmental data. It's nanograms or per cubic meter or, parts per billion, parts per million.
Yes.
How do you communicate? What's your tips on this webinar in the time we have remaining on how you communicate environmental data? And maybe we go to the next slide here on this one.
It's tough, isn't it? I mean, as a political science major, I was a political science major because there was no math involved. And so when you start talking to me about parts per million, parts per billion, right, I sort of check out a little bit. The challenge with communities is that we often go in with a very high level of information about what's going on at the site, but the community's information level could be very low. Maybe they just know what they've Googled, right? But their emotion, so that's those folks on the right-hand side, that's the public in a high emotion condition. They have a lot of emotion, but maybe not a lot of information. And maybe a lot of that information they've gotten through Google, so it's not accurate. Maybe some of it they've gotten from their neighbor, also not accurate. But we walk into those communities and we're that slide on the left, we have a lot of information. We know what's going on with this project. We know what's happening. We may not have a lot of feelings about it because we're very involved in the process. We're very involved in the facts of it. And you can see, you can imagine, right, how someone in a high emotion state talking to me in a low emotion state with a lot of information, like sometimes that doesn't turn out well. And it's hard for people who are in high emotional states, just reflect on yourself, to take in new information. So one of the things we like to do is we like to have open houses that have boards and experts in the open house. There's no microphone, there's no formal presentation. People are then at their leisure, at their own timing, at their own speed, able to go and take in the information and learn about what is happening at the site rather than making it up.
Well, that's interesting. Let's go to the next slide, and you can talk about some of the resources that are available. And let's just step back for a second. I mean, what's happening now with the Southern California fires, Kit, isn't it, is really a case study in
It
how
is.
to communicate these type of things to the public. And I know it's not directly relevant to our hypothetical, but we have issues now with lead and metal testing in the Palisades and Eaton Canyon. These photos here are from residents in Calabasas that are concerned about disposal of the debris and whether or not it meets the typical landfill standards, whether certain waivers have been given. We have real issues with government trust. There's an emerging issue with the Army Corps of Engineers, and I'm no expert on this, but that allegedly has changed its policy that instead of doing testing after they do debris removal, they're just going to go down 6 inches and not do further testing. There's going to be case studies and analysis of how we've dealt with the P2, the public participation and government trust aspects of this whole thing with the fire. Now, there are many, many resources available. As you mentioned here, Kit, this is a great website from the International Association of Public Participation, where you chair the Southern California group. But in general, how do you deal with the kind of situations that we're looking at here on the screen?
Well, Gideon, it's so hard, and we all have so many feelings for those folks who have suffered from the fires, and our hearts break for them and what they and their families have been through. And then isn't it interesting that folks in communities that are taking some of this waste or dirty dirt from the sites then are protesting taking this waste into landfills in their community? And so I would just say it's a couple things. One is we're trying to move really fast with this dirty dirt coming off the fire sites, right? We haven't taken just a beat to then tell people what the situation is with what is coming into their community. So it's not just focusing on the folks who, of course, have been impacted by the fires in a very tragic way, but it's the folks also taking that waste who need to be informed about what's happening in their community too. It's kind of that, where's the trash coming from? And then where's the trash going? And communities in both of those stages need to be well informed. And it's hard to inform folks when people are in a high emotional state and when you're trying to do it as fast as we're trying to do this down in Southern California.
So
very, very hard.
That takes us to our next slide, which I want to spend a couple minutes on, which is designing this process. We have a 5-step process. Maybe we can bring it back to our site. We have our hypothetical. We are trying to redevelop this site. It's an Earth Day type of project. You've got an abandoned or underused strip mall we're trying to put back to productive use. We're trying to bring housing to this site. So how do you design this P2 process? And in particular, what's the goal for our site? Are we just trying to get through the process? Are we trying to reduce litigation risk? Spend a couple seconds here or a minute or two on this slide here, steps 1, 2, 3, 4, and 5, Kit, and what's our goal?
So important to know, right? Because sometimes our goal under CEQA is simply meeting the requirements of the law. Sometimes really what we want to do is engage the community and get their input and feedback on what we have planned for the site. So knowing your why is super important. And where my clients have gotten sort of hooked up is they've decided they want to be like the heroes of the community, and they've gone out and they've communicated, but they haven't known why they were communicating. So knowing why you're there, are we just checking a box and meeting the minimum requirements of the law? Look, y'all, that's just fine. That, as long as you know why you're there, right? And we're not asking necessarily for the community to have input, but we do want to make sure everybody is informed. So knowing your why is key, because that's a foundation on which you're going to build all of your other activities 2, 3, 4, and 5 years. So just like Alison said, create a team. Don't go it alone. Y'all, I know it's really popular to cap on the lawyers. I love lawyers. I am not a lawyer. I work with lawyers on every single team I have, and I love it because y'all keep me out of trouble and you remind me why it is that I'm doing the public engagement. So having a team is just so unbelievably helpful. Also, you can burn out really fast doing public engagement and public participation, knowing your stakeholders. So who in the community is a mover and shaker? Who in the community is sort of the person on the hub for the Facebook page or the Nextdoor page for that community? Because that person's going to be saying things and people will listen to that person. Getting to that person is very important. And then making a plan. I know it seems obvious,
before we get
but
to the plan, and this is a key
sure.
point, we talk about with the stakeholders, cultural competence is very important.
Yeah, it is. It sure is. And, I'm a middle-aged white woman. And so sometimes it's not necessarily the best thing to send me into communities because we all know that we take information in best from people who probably are our neighbor, the person who's closest to us, the person that we trust. And so it's important to remember that when you're engaging with communities, especially communities that have been historically disinvested, haven't been listened to over long periods of time, that you want to make sure that you're aware and sensitive to the fact that you may be somebody going in to talk to folks who doesn't look like the folks that you're talking to.
Right. And so that goes into point 4 that I interrupted you on there, making a plan.
No. That's just fine. So making a plan, and then I like to plan the work and then work the plan. You can have a lot of feelings during the public engagement. Having a plan is key because it's going to keep you on track. It's going to keep you on scope, on budget, and on your timeline. And then continue to implement, monitor, and adjust, because as you do public participation, it's iterative, right? So every time you're in the community, you're going to learn something new. And then you're going to go back and adjust your plan given that new information that you have.
Mm-hmm. And for a site like this, we may have fact sheets that go to thousands of people.
We could have fact sheets. We could have websites. We could be buying social media ads. We could be doing paper mailers. We could be doing walking and knocking if the community is a little bit older and folks aren't on social media a lot. I love walking door to door, talking to neighbors and answering questions. Those questions they have right there at the door often have a lot of feeling behind them, and you can just start to diffuse that right away.
Good stuff. No, thank you for that, Kit. So in the remaining 15, 20 minutes that we have, we're going to now go to the next slide, which is, okay, we may have to get involved in litigation for our site. And so we've got a real expert with particular insurance expertise to talk to us about this. What does environmental litigation look like? There's your federal stuff under CERCLA. Related to that is federal RCRA cases for imminent and substantial endangerment. Kind of similar causes of action, both federal court causes of action, but very different, and a lot of process involved, and of course, that the lawyers generally have to be up to speed on in terms of asserting CERCLA claims and how do you perfect those. And the same with RCRA. Have you touched on the different elements of the cause of action and pled all of those? You could have supplemental jurisdiction over your state law claims under California's Hazardous Substance Account Act, which again is in the Health and Safety Code, or maybe you're just bringing those cases in state court under the HSAA. You also, in addition to the statutory claims, could have common law claims, extremely common in this area, continuing or permanent nuisance and trespass. You could have negligence claims. So there's a whole list of causes of action. There's a whole list of different venues you could think of for environmental litigation. And these are the topics that we're going to introduce here for Jon-Erik, starting with the next slide.
Thank you, Gideon. So there's a wide variety of litigation avenues, but first and foremost, you as the client working with your attorney, you need to define your litigation goals. And it's really not just an exercise of getting the pleading right. It's trying to figure out what you want to do with your lawsuit. And traditional litigation goals include cost recovery. What are the past costs that you need to recoup doing your investigation? What is your injunctive relief for future costs? And just for those that may not know, under CERCLA, RCRA, HSSA, you do not get a damages award for future costs. You get an allocation, you can go back to the court and you can recover a percentage of costs as you incur them. And then I would also say it's not something that's granted by the environmental statutes, but in my experience, sometimes to get parties to enter into a reimbursement agreement or a cost sharing agreement to actually get work done at a site, that lawsuit needs to be filed. It's kind of the necessary segue. There are also other objectives with litigation. It's not just a specific relief, it's triggering insurance. Can you trigger insurance assets, which we're going to talk about in a little bit? Incentivizing recalcitrant PRPs. Do you have PRPs at the site, the former owners, the former operators? Are they not participating? Are they ignoring your letters? Sometimes you need to do something to get their attention and make them respond. And then sometimes there is issue specific resolution. And that can include anything from, does a particular defendant with a particular contaminant, are they appropriate under CERCLA? That is often seen in the context of petroleum defendants. Do you have a specific issue with the remedy that's being deployed? Is it consistent with the NCP? Are there successor issues where
The NCP?
you have what's that?
The NCP?
No, successorship issues.
Oh, no, you mentioned the NCP, but for those that don't know, it's
okay.
the national, yeah, go ahead.
You're right. The National Contingency Plan, to recover your costs must not be inconsistent. Your cleanup cannot, it's a double negative, so it's always very hard to say. I'm sure like people are looking for orange buoys to send me right now. Your costs cannot be inconsistent with the NCP. So effectively, you have to file the set of regulations promulgated under CERCLA to recover your costs.
Yeah.
And then successorship issues almost always come up in historical claims because you have a long line of businesses that operated at one site forever, and that's how you end up with the impacts in the one place. I do want to double down on one point, and this is something that comes to me from my time as in the insurance industry, where effectively I was client side, and that was always understanding when you start litigation, you get involved in litigation, understanding where the exit strategy is. I would say a majority of experienced environmental litigators understand that litigation is not the most effective, cost-effective way to resolve environmental claims. So there needs to be another strategy. There needs to be another end goal to leverage that litigation, and it can change over time. But the day that lawsuit is filed, if your sole goal is to go to trial to get a judgment or an allocation, query whether or not your monies could be better spent. I was just involved in a lawsuit down in LA. A win was a $7 million settlement. This is not for my client, for another client, but because there was a companion coverage action, we saw that they had spent $6 million to get that. I would say that that's an imbalanced ratio of expense to money going into an environmental project.
Yeah, it's sometimes easier to start the environmental litigation than it is to end it.
100%, 100%.
Yeah, good. Let's go to the next slide. Yeah, so the insurance coverage is just such a key part of this, and we're so pleased to have you here with all your experience, Jon-Erik. So this is a little bit of the basics, and then we'll dive down to our masterclass.
Exactly. Long story short, I mean, there's good money, and then there's better money, which is generally insurance money, especially when it comes to paying for environmental cleanups. Generally speaking, we're talking about primary policies, aka the general liability, the commercial general liability policies, and in particular, we are looking for policies prior to 1985. Policies post 1985 have what is known as an absolute or total pollution exclusion. Courts in California have basically upheld that exclusion. Your claim for historical environmental pollution is not covered under that policy. Policies prior to 85 have what's known as a sudden and accidental pollution exclusion. Courts have generally construed that in favor of policyholders. It's not a high hurdle to trigger a duty to defend or even potentially get around it for purposes of indemnity. The issue becomes trying to find a policy 1985 or earlier. You're 40 years back in time, and how do you do that? There are some firms that are very skilled at doing that. Generally, I think there's a consensus that it makes sense to hire an insurance archaeologist. I mean, these are skilled professionals that are like the Indiana Joneses in a legal sense of going back. They have certain resources, they have certain databases that they can look at to help find evidence of insurance, and that can result in a tender to an insurance company that might get you policy benefits. But it's a process that is worth doing because, as everybody knows in this webinar, environmental claims are very expensive to resolve, both in terms of litigation, but also the actual cleanup of the site itself.
Right. And a lot of times what you can see is if you're lucky enough to find one of those policies, if you've got a talented lawyer that helps you navigate that and find one of those policies, all of a sudden that lawyer's out of the job as the thing gets tendered to the insurance company, which potentially will pick it up with their own counsel on a duty to defend. Let's go to the next slide. Yeah, this is an issue here. If you want to talk about these, are these sort of like emerging and hot types of claims, Jon-Erik?
Hot as that term was used in Zoolander. No, I don't say it's hot. But what I would say is it's the same issue that you have trying to find a 40-year-old insurance policy. Individuals and businesses that may have existed 40 plus more years ago, they're more difficult to find. Sole proprietors, they're deceased. Businesses, especially closely held businesses, they're just not around anymore.
Right, well, like the person who operated the dry cleaner at our site years ago, right?
Exactly. I mean, it is not uncommon. In fact, it's very common that the folks operating a dry cleaner do it as a sole proprietorship or a partnership. The same name has been used on the business for numerous years, but different people own the business from time to time, and trying to find that entity or that person from 40 plus years ago can be really difficult. But if you can find those insurance policies, you don't necessarily need to find the individual. And in particular with deceased individuals, deceased sole proprietors, you don't have to go to probate, which, by the way, I've done it. I don't recommend it unless you're a probate attorney. It's strong pass on probate court.
Good. Yeah. Let's go to the next slide. Okay.
So triggering coverage, long story short, to get insurance benefits in California, you need a lawsuit. The standard CGL language responds to lawsuit. The duty to defend is respond to a lawsuit. But I will pause here to say something that everybody should know, which is if you find any policy, look at it, read it front to back, make sure you have all the endorsements. Certain carriers in the late 70s, early 80s had unusual policy language under their what are called BOP policies, and in their umbrella policies. Duty to defend could be triggered by a lawsuit or a claim. So you have to look under the hood. You really need to get into the nitty-gritty on all these policies to make sure that you're not missing an opportunity for coverage.
Let me ask you a question, if we can stay there.
Yep.
Let's talk about reservation of rights. Are you seeing on these environmental insurance cases that that you're not getting full indemnity from the insurer right away, that you're seeing reservation of rights? Maybe it's sudden and accidental. Maybe they're defending you, and they're going to pick up the duty to defend, but they're not necessarily on the hook for indemnity, and nobody's filing a deck relief action, but we're sort of doing this dance. That's pretty common, right, Jon-Erik?
So if we go back in time, maybe 15 years, when I was working for the insurance industry, like, it actually would not be uncommon to just get a letter saying, we'll participate in the defense, no reservation of rights. Carriers have become much more sophisticated. They are much more attuned to environmental problems. I would say a high majority of the times, if a claim comes in, you might get a reservation of rights letter from coverage counsel retained by the insurance company. I would say that if you tender this claim to an insurance company, there's a sudden and accidental pollution. There's no doubt in my mind that you're getting a reservation of rights letter in response.
Right.
And what that means is you have to be wary of a bus reservation in reference to Jerry Buss, late LA Lakers owner. And what that means is the insurance carrier has reserved its right to recoup those costs of the defense that apply to the non-covered portion of the claim. So if a carrier defends, it's got to defend the whole thing. It can't just pick and choose what it wants to defend. It's got to defend the whole kit and caboodle. But at the end of the day, if there's a determination that there's a portion that was uncovered, the carrier could conceptually recover the cost it spent to defend the uncovered portion of the claim.
And that's no good, having that hang over you. Let me ask you a question here. In mediation, okay, you've got a reservation of rights. So there's a coverage issue. There's a question about indemnity, but we're trying to get the insurance company to participate. Now, let's say you're on the defense side, you just represent the insured. You're not there to deal with the coverage issues, but you've got to sort of walk that fine dance. Are you okay with mediators saying, listen, I know, Jon-Erik, you don't want to hear about the coverage issues, and that's not for you because you've got a duty to represent the insured. But is it okay if me, the mediator, can I pull the adjuster who's at the mediation into a separate room and kind of talk through some of those issues and get a sense of where they might be? Are you okay with the mediator doing that? I mean, of course, I wouldn't do it without asking you, but are you okay in that instance to talk about the coverage issues with just the adjuster or maybe the insurance coverage counsel for the company?
So let's make a quick delineation. So if you're effectively panel counsel, right, you're a part of the tripartite relationship, you represent both the policyholder and the insurance company. Yes, that's an appropriate question to ask. And if the carrier is there with its insurance counsel, and you need to go, as the mediator, need to go have a separate discussion with them, and they sound like, I think there's nothing you can do, and I think you need to sign off on that. If you're Kumis counsel, on the other hand, right, you were retained by your client who just happens to be a policyholder, you have no relationship with that carrier, right? And quite frankly, my message to the mediator is often, hey, you need to beat these guys up a little bit. I don't think they're being realistic. Their expectations they're not reasonable in light of what we're trying to accomplish here. Maybe some of it's theoretical, but they haven't done their homework to show that they can stand on their coverage defense.
Yeah, got it. Yeah, interesting role for mediators in these situations. We have 2 more slides. Let's go to the next one, page 21.
Yeah, and I just want to, but Gideon, you hit on something really important, because this is something that I'm going to talk about right now, is that you can often do an early mediation in these kind of cases, and you can get your PRPs together with your insurance companies, and you need somebody oftentimes to facilitate that discussion, right? An early mediation with a great mediator like yourself to kind of bring everybody together to understand, we can spend a lot of money litigating things, or we can work collectively, enter into a cost sharing agreement, get an agreed scope of work, maybe go a little bit further, right, and get a litigation stand down. We can advance the project at the site, which also has the effect of collecting information to advance the litigation if and when we need to go there. But you need somebody who is a skilled communicator to kind of help get everybody aligned and everybody on the same path going forward. So going back to our site, if we're working with other RPs at the site, our lawsuit, we've named as defendants all of the RPs, the former owners, the former operators. We've got their insurance either through tender or through some sort of probate action. And we're making a pitch, the plaintiff is making a pitch, or one of the parties is making a pitch, like, let's do a collective investigation, let's develop site data, and let's move things forward. And again, I call this the kumbaya approach. Your mediator helps you get from point A to point B and get all that into an agreement.
And let's go to the next slide on this, Katie, which kind of depicts this.
Yeah, and that's it. The first thing is, can you get everybody to the table, right? You need your PRPs, you need your insurance carriers, and then can you get consensus on understanding what the combined objective is. What kind of investigation do we want to get accomplished? And then to the next point is, how do we phase the investigation? How far can we get this under the guise of whatever relief we might have gotten from the court vis-a-vis a litigation stay or just the timelines of the litigation? Going back to one of the earlier slides, you have to understand what your litigation objective is. Do you just want to litigate and enrich attorneys, which is great? I'm happy to do that. I'm happy to take cases to the trial. Or do we want to try something that's more of a collaborative approach to really see if we can affect resolution of these environmental claims?
Right. And so for our hypothetical, you get the parties together early. You figure out, okay, this is what needs to be done at the site. Maybe we can get a cost sharing agreement on these investigations, a stand down on the heavy litigation, and then you set the foundation for potential success at our site in coming to that ultimate remedy that both Kit and Allie are going to help you with. So
Yeah.
thank everybody for this. Let's go to the last slide. That's all of our time. Happy Earth Day. Thank you, Alison. Thank you, Kit. Thank you, Jon-Erik. Thank you, Katie, of course. Here's the contact for everybody. Big applause I'll give you. And I want to thank all of our attendees for making a difference in your communities too, a difference in your clients' lives. And from all of us, we'll see you at the next mediation. Thank you, Katie.
Thank you, everybody. Thank you to our speakers. Thank you very much, Gideon, for moderating this fantastic panel, and all of our speakers for your time and expertise today.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.